mobile app, on your Alexa-powered smart speaker, and on TuneIn, iHeart, and on Odyssey.
From the Matrix Home Solutions Studios, this is Chicago's Morning Answer on AM 560, The Answer.
This is Chicago's Morning Answer with Dan Proft and Amy Jacobson on AM 560, The Answer.
Top of the morning, Dan and Amy. Yesterday, the Dobbs case before the High Court, oral arguments on a case that has the potential to see Roe v. Wade overturned. And Justice Clarence Thomas questioning U.S. Solicitor General Elizabeth Prelogar, who is representing the federal government in opposition to the Mississippi law and in proposing to maintain Roe v. Wade as good law, even though it's, as I said before, right up there with Dred Scott among the worst decisions in Supreme Court history. And in the back and forth between Thomas and Prelogar, Thomas is just trying to get to what the argument is. What exactly is it you're saying? Is it a viability issue? Is it an autonomy issue? It is an undue burden issue? What is this right and its basis?
General, would you specifically tell me, state what the right is? Is it specifically abortion? Is it liberty? Is it autonomy? Is it privacy?
The right is grounded in the liberty component of the 14th Amendment, Justice Thomas, but I think that it promotes interests in autonomy, bodily integrity, liberty, and equality. And I do think that it is specifically the right to abortion here, the right of a woman to be able to control without the state forcing her to continue a pregnancy, whether to carry that baby to term.
I understand we're talking about abortion here, but what is confusing is that if we were talking about the Second Amendment, I know exactly what we're talking about. If we're talking about the Fourth Amendment, I know what we're talking about because it's written, it's there. What specifically is the right here that we're talking about?
Well, Justice Thomas, I think that the court in those other contexts with respect to those other amendments has had to articulate what the text means and the bounds of the constitutional guarantees. And it's done so through a variety of different tests that implement First Amendment rights, Second Amendment rights, Fourth Amendment rights. So I don't think that there is anything unprecedented or anomalous about the right that the court articulated in Roe and Casey and the way that it implemented that right by defining the scope of the liberty interest by reference to viability and providing that that is the moment when the balance of interest tips and when the state can act to prohibit a woman from getting an abortion based on its interest in protecting the fetal life at that point.
So the right specifically is abortion?
It's the right of a woman prior to viability to control whether to continue with a pregnancy, yes.
Thank you.
It seems to me that Thomas was trying to get at the penumbras and emanations that Justice Douglas found in Griswold v. Connecticut that then Justice Blackmun picked up in Roe v. Wade. But let's get another legal opinion on this. We're pleased to be joined by Mary FioRito, who's an attorney, as well as a spokesperson for Parents for the Protection of Girls. Mary, thanks for joining us. Appreciate it.
Oh, thanks so much for having me. Did you notice her verbal slip that she used the word baby?
Yes.
And fetus. Also,
yes.
Women were not people anymore. Just for yesterday, we were back to being women.
Right. Okay. But in terms of, you heard what I said about what I thought Thomas was getting at. What was your take on his line of inquiry?
Yeah, well, he had a couple of different lines of inquiry. First of all, the one that you mentioned, where he is trying to get them to answer, where is this constitutional guarantee that you're relying on? Is it in privacy? Is it in autonomy? But, as you heard in her response, she was sort of all over the place.
It's everywhere.
Yeah, it's everywhere. I mean, she was saying all sorts of different things. So I think that suggests that Thomas might write, in his opinion, that the 14th Amendment guarantee of liberty is just too vague, it's unspecified, it doesn't provide the firm ground to the right to kill an unborn human being, but they think it does. So I think that's where he was getting at with that particular line of questioning. Then he had another line of questioning about bodily autonomy, and I thought he was quite good to press the other side on this point, which was, if autonomy is sacrosanct and it can't be touched, then is it wrong for states to make it illegal for women to ingest illegal drugs or somehow harm their unborn child during pregnancy? And the other side squirmed around that one as well. So I was glad he really held their feet to the fire.
And on the matter of, if this is a matter of choice and non-viability, sort of taking all the arguments that they were arguing in the alternative throughout the course of the day, then Justice Roberts chimed in and said, well, if it's about choice and not viability, then why is 15 weeks not enough time to make a choice?
Right, exactly. And I was pleased to see him being as firm as he was. We've both been disappointed in some of his decisions and his seemingly unwillingness to be a little more sort of straightforward on his positions on abortion. But he did seem to signal yesterday that he is willing to go what I think may be a 6-3 decision. And the other side was, they kept talking about viability to your 15-week point, saying that nothing has changed and they're just all about viability. Well, we all know viability has changed dramatically since 1973 and even since 1992 when Casey was decided. I mean, I have a nephew who was born at 22 weeks, 0 days, and is a perfectly happy, healthy little boy today. And, we have wonderful NICUs here in the Chicago area that are able to save babies as small as 21 weeks. So when the other side keeps talking about, some kind of magical line between 24 and 28 weeks, they're not even acknowledging the current science, which clearly puts viability with the right NICU and doctor at about 21 and a half weeks.
What was your take of Justice Sonia Sotomayor, who used her questions on abortion rights to urge her conservative colleagues to follow precedent and not politics in deciding the case?
Yeah, I'm glad you asked that, Amy, because there's a lot there with Sotomayor. First of all, she cut into the Mississippi Attorney General's time significantly by all of her questionings. I think that was done intentionally. I'm sad to say that because, as Dan well knows, when you're trained as a lawyer, courtesy and decorum is all part of your training, especially if you're arguing before the court. She was quite, I'm sorry, I don't have a better word, but she was quite unhinged. I thought, how much coffee have you had this morning? She was very angry. She came right out of the gate right at him. A lot of her questioning, I thought, was very pointed. It didn't seem to get at some of the legal issues. It was more sort of a, as somebody said on Twitter, it was kind of funny. She seems to be writing her dissent as she's talking. So it was. Well,
sorry to interrupt. There's something else about her line of argumentation, and that was really argumentation. It wasn't questioning. Where she talked about, can this court survive essentially overturning Roe v. Wade? So she's, on the one hand, decrying a political reading of the Constitution, as she characterizes, and at the same time saying we have to uphold Roe v. Wade for political reasons.
Right, exactly. And, again, it sounded to me like she was reading a Planned Parenthood press release. She was using every trope, every ridiculous argument, including asking Mississippi if whether or not this was really just all a religious argument and religiously based, which I thought was incredibly inappropriate. This is not a religious argument. No one on either side, with all the amici briefs that were filed, made any kind of religious argument. So again, it was all of these things that you hear, the other side talking about, when they're doing their little talking points in favor of abortion, that this is really just religious people trying to control women's bodies. I was very disappointed to see her stoop to that level, frankly. So, and
with the viability issue, one of the issues they raised repeatedly, is it correct to read that as they believe that is their weakest argument, which is why they sort of danced around it? You had Sotomayor sort of dismiss any science related to fetal pain pre-24 weeks, that's fringe medicine, or a few fringe doctors believe that. Do they think that's the weakest argument, number one, because of medical advances that you were describing before? Number two, because even Blackmun suggested that sort of this, the trimester or now subsequent to Casey, sort of the 24-week line is arbitrary.
Right, and Blackmun even said it was dicta. So, but no, I don't think they think it's their weakest argument, and I don't think they believe in viability as an argument. I was rather astounded they kept asserting it because, as you know, and I think one of your callers earlier this morning pointed this out, when you look at Roe versus Wade and Doe versus Bolton, its companion case together, there is no limit on abortion in the United States. We are one of 20 countries in the world. We are one of 7 countries in the world, along with North Korea and China, which Justice Roberts pointed out, that permit elective abortion, so healthy mom, healthy baby, after viability. there are very few countries in the world that permit that because the health exception in Doe versus Bolton is so broadly defined to include things like age and whether or not you have other children. It's an exception that swallows the rule. So when they want to codify Roe, when they argue in favor of Roe and Doe and Casey, they are arguing in favor of abortion for all 9 months for any reason. They know that. They don't believe in a viability restriction.
Yeah,
they never have. So the
I
very
know.
fact that they're arguing, to me, is bizarre.
Well, right, but it also suggests to me that's kitchen sink, and they're throwing that in, but they don't believe that's their strongest argument. Politics is essentially their strongest argument, combined with this, this right, because of course the left is great in manufacturing rights out of whole cloth, and that to me is I think where they think the strongest cases to be made, certainly before the public, and then using the public to put pressure on the justices to protect this right that they invented in 1973.
Right, exactly, and you are exactly right. This was for public consumption. This was not a legal argument. What they want people to think is that they are reasonable. They're really only talking. They don't believe in abortion after viability. No. That's they are very reasonable, responsible people who really are kind of in step with what most Americans think, and that is not the case. They believe in abortion for all 9 months. They have advocated it for years. When in Congress, they wanted to pass the law. In fact, the House passed it. This Reproductive Freedom Act, which essentially codifies Roe, which makes abortion legal for all 9 months when you include that very, very, very broad health exception. So this was meant for public consumption. It's why they used the word woman instead of birthing people. It's why they kept saying, "Oh, we believe in viability. We're just reasonable people here." That's what they were trying to get across.
Yeah.
I listened with another group of lawyers yesterday morning. We were all looking at each other like, who is this? Like, what are these people talking about? Because it's so unlike the pro-abortion movement that we know and have, tried to contradict all these years.
One other legal argument that was made, though, or legal concept that was addressed, this one by Amy Coney Barrett, the undue burden standard out of Casey. And she went right after that talking about safe haven laws that allow for parents, moms, to give up their children without repercussion as quickly as within 48 hours of birth. And so she really tried to sort of narrow that as an issue with respect to limitation on abortion.
Right, and that's because in the Roe decision, Blackmun grounded the right in terms of women not being forced into parenthood, not necessarily pregnancy, but rather parenthood. So that's what Amy Coney Barrett was getting at. You can address the parenthood issue in all 50 states within 48 hours. You just show up at a fire station or a police station or a hospital, turn over the baby, no questions asked, and parenthood rights are severed automatically. But then, in one of the more bizarre lies that the other side got away with yesterday, she responded that no, pregnancy is incredibly dangerous, and literally stated 75% more dangerous than not being pregnant. And so I don't know, Amy, you and I should not be alive, apparently, because we were in incredibly dangerous medical situations. Who knew? She was able to make the statement with no one pushing back on her and with absolutely no facts to back her up. I was rather astounded by that.
Well, that's just sort of like the inventions you get. It's just throw out a statistic this is saying in a genteel way in that setting, back alley abortions and women's health is at risk, right?
Right. Well, but it's just absolutely absurd. Pregnancy is not 75 times more dangerous than not being pregnant. She had absolutely no factual basis to this. A pregnancy is a very healthy, natural state for a woman to be in. In fact, not being able to get pregnant is considered an illness or a disability by doctors, right? It's the fact that your body can actually do this means it's operating the way it was intended to. And we have wonderful medical care for pregnant women. And if, complications do arise, we're able to deliver babies earlier and earlier, most oftentimes saving both mom and baby. So, trying to raise that specter that, women are going to die if we don't have abortion. And, just to go back to the Mississippi law in particular, it doesn't outlaw all abortions. It restricts them at 15 weeks, which is almost 4 months of pregnancy. And most of Europe, 47 out of 50 countries in Europe, pretty much toe that line, if not earlier, if not at 12 weeks. And when you ask people, right, there were all these polls this week, do you support Roe versus Wade? And most people say yes. But when you ask people, well, do you support sex selection abortions if the baby is a girl and the family wants a boy? Well, no. Well, Roe allows that. do you support abortion? Let's say 32 weeks because couples decided they have a fourth child. They don't want a fourth child and they already have 3. Well, no, I don't support that. So when you really get into time and distinctions and reason, most American people will say first trimester only. After that, only in very limited and restricted conditions, which makes the Mississippi law even more liberal than what most Americans would say they want.
But your net from the oral arguments, and of course this is always dangerous business, reading the tea leaves from Supreme Court Justice questioning, but by the end of next June, Roe v. Wade is overturned?
Yeah, it's gone. Yeah. I saw a terrific headline in The Atlantic, of all places, last night, the end of Roe, and I think they're right. I think it's probably going to be a 6-3 decision, maybe 5-4, but I think it's going to be a 6-3 decision. I don't see, based on oral arguments, and Dan, as you well know, oral arguments don't really have a huge influence on how the case is decided. I know a lot of people think that, but the justices have largely made up their minds before they come in to hear oral arguments. So and the questions are used to sort of refine their arguments, which is why I think Sotomayor went off on the crazy tangents that she did. But that being said, I do think based on some of the questioning, particularly from people like Kavanaugh, who people might have had questions about, and Chief Justice Roberts, I think we're looking at a 6-3 decision.
She is Mary FioRito. She's an attorney. She's also the spokesperson for Parents for the Protection of Girls. Mary, thanks for joining us. Appreciate your insights.
It was a pleasure. Thank you so much for having me.
Thank you. And she joined us on our turnkey.pro answer line.
The stories you need to know to start your day. This is Chicago's Morning Answer on AM 560. The Answer.
The holidays are fast approaching, and now is the time to make sure your home is ready for your family and friends. Imagine how beautiful your home can be by upgrading your bathrooms or a fully remodeled basement. Call Matrix Home Solutions, sponsor of AM 560's Freedom Summit. When it comes to top quality home improvement projects, no other company comes close to Matrix. They focus on the major areas to increase the value of your home and improve your lifestyle. Basement remodeling, bathroom transformations, custom garage flooring, and storage. Take some time today to visit their website, matrixhomesolutions.com, and